Political Science, Theory of Separation of Powers. In West Bengal Higher Secondary Examination, you may face three types of questions regarding this topic, and you have to answer accordingly. The first type of question is, what do you mean by the theory of separation of powers? Discuss the arguments in favor of and against this theory. So, in the first part of this question, you are asked what the theory of separation of power is. In such type of questions, you have to put stress on the introductory part. That means you should elaborately discuss the introduction, the definitions, the maxim or the basic maxim, and the propositions. The second type of question is, analyze the arguments in favor of and against the theory of separation of powers. Here is an equal number division between the arguments in favor of and against this theory. So, you have to put equal stress on both aspects. Many students put stress only on the arguments against this theory, but in such cases, you will not get the marks allocated for the arguments in favor of this theory. And the third type of question is, define the principle of the separation of powers. Complete separation of power is neither feasible nor desirable. So, for the first part of this question, you have to elaborately discuss the introductory portion, and for the second part, you have to put stress on the arguments against this theory. Here, I will discuss the whole theory elaborately so that you can cut and adjust the answer according to the question. So, let's start the answer. Introduction. The principle of giving autonomy to the three organs of the government in their respective fields, that is, to the legislature for making laws, to the executive for running administration, and to the judiciary for discharging judicial functions, have been known as the principle of separation of powers. So, the advocates of this theory are of the opinion that it is desirable that the powers of the three main branches of the government, that are the legislature, the executive, and the judiciary, should be clearly defined and separated from each other in such a way that each of them could exercise their powers and perform their functions independently. This theory is strictly against the accumulation or concentration of powers in the hand of one person or a group in order to prevent autocracy and protect individual liberty. Definition. According to R.C. Agarwal, where all the powers of the government are not concentrated in the hands of one organ, it is called separation of power. Richard Manuel and Ona Gay define the idea as separation of power refers to the idea that major institutions of the state should functionally independent and that no individual should have powers that span these offices. Maxim. The separation of power is based on the concept of trias politica introduced by Montesquieu. This principle visualizes a tripartite system where the powers are delegated and distributed among three organs outlining their jurisdiction each. Propositions. There are four basic principles behind this doctrine. Number 1. The legislature, the executive, and the judiciary. These three organs of the government will remain independent from each other. Number 2. One organ of the government will neither perform the functions of another nor exercise the powers of another organ. Number 3, same person or same group of people will neither look after the affairs more than one organ nor in any other way connected with more than one organ. And number 4, one organ will not try to control or interfere in the affairs of another organ. If there is 3 marks or more than 3 marks for the part of the question, for the first part of the question, that is what the theory of separation of power is, you may include this portion. Basic tenets. Montesquieu propounded that number 1, the executive should not exercise the legislative or judicial powers because this may threaten the freedom and liberty of individuals. Number 2, the legislative should never exercise the executive or judicial powers, as this may lead to arbitrariness and hence end the liberty. And number 3, the judiciary should not exercise the executive or legislative powers because then a judge would behave like a dictator. So, Montesquieu not only discussed the propositions but why such theory is necessary, he has also explained that. He explained that if the executive exercises legislative or judicial powers, it may threat the freedom of liberty of individuals. And if the legislative exercises the executive and judicial functions, it may lead to arbitrariness and hence end the liberty of individual. And if the judiciary exercises executive or legislative powers, then the judge will become a dictator. According to Wade and Phillips, the principle of separation of powers meant 3 things. Number 1, one person should not be made part more than one branch of the government. Number 2, there should not be any interference or control of any organ of the government by the other. And number 3, no organ of the government should exercise the functions and powers of the other organ. Advocates. Greek philosopher Aristotle, Roman political scientist Cicero and Polybius, French jurist Jean Bodin, Italian politician Marsilius, English philosophers Harrington and John Locke have indirectly hinted the effectiveness of this theory in their writings. However, this doctrine got a proper shape through the books Esprit des Lois, that is, The Spirit of Laws, published in 1748, written by the French political scientist Charles Louis de Montesquieu, and Commentaries on the Laws of England, published in 1765, written by English jurist Blackstone. American politicians Hamilton and Madison are the main supporters of this theory. Here in this chart, you may see at a glance the advocates of this theory. Historical evolution. This theory traces back to the time of American Liberation Movement and French Revolution. At first, USA has inserted it in its constitution in 1787, and afterwards in 1789 France and later Argentina, Brazil, Mexico has adopted this principle. Arguments in favor of the theory of separation of powers. The advocates of this theory has mentioned some advantages of this theory. That is, number 1, prevents tyranny. It aims to eliminate arbitrariness, totalitarianism, and tyranny and promote an accountable and democratic form of government. The reasons on which Montesquieu grounds this theory are further demonstration of his intention. According to Montesquieu, if all the powers of the government has been concentrated in the hands of same person or same group, he, she or they will enact tyrannical laws, apply it in an oppressive manner to regulate and control administration, and overshadow all the voices of opponent and challengers arbitrarily through the parodies of justice. James Madison has remarked that the accumulation of all powers, legislative, executive, and judicial, in the same hands, whether of one or a few or many, and whether hereditarily or self-appointed or elective, may justify be pronounced the very definition of tyranny. Lord Acton said that power corrupts and absolute power tends to corrupt absolutely. Number 2, secures liberty. The greatest merit of the separation of powers is that it excludes all hindrance to individual liberty. If same person or group become absolutely powerful, individual liberty would be exposed to his, her or their control, because he, she or they would be the tyrant ruler, the oppressive executor, and the arbitrary judge. Blackstone observed that if the legislative, executive, and judicial functions were given to one man, there was an end of personal liberty. Number 3, safeguard against the misuse of powers by organs of government. The Constitution provides certain limits and boundaries for each domain of the government, and they are supposed to perform their functions within such limits. The Constitution is the ultimate sovereign, and if anything goes beyond the provision of the Constitution, it will automatically be considered as null, void, and unconstitutional. Number 4, creates responsible government. It keeps a check on all the branches of government by making them accountable for themselves. Moreover, as the responsibilities of every organ of the government are defined and clear, no organ could shift the responsibility of its fault upon another organ. As a result, every organ of the government functions in a responsible way. Number 5, facilitates a check and balance upon each organ. Separation of power maintains a balance among 3 organs of the government by dividing the powers among them, so that the powers do not concentrate on one branch, leading to arbitrariness. Montesquieu remarked that the 3 powers must be separated and exercised by different individuals in such a manner as to act as check and balance upon one another. Number 6, increase efficiency of the government. This principle allows all the branches to specialize themselves in their respective field with an intention to enhance and improve the efficiency of the government. Number 7, ensures speedy transaction. When the branches of the government are free from the interference, their working speed will automatically increase. Number 8, provides simple and transparent system. As the boundaries of their powers and functions are definite, there will be no complexity in their working field. Criticism. Criticism against this theory of separation of powers from different angles started from the second part of the 19th century. Before that time, this theory gained popularity. Number 1. Practical implementation is impossible. Strict separation of powers is a theoretical absurdity and practical impossibility. Historically speaking, there was no absolute separation of powers in any country. Number 1. As the branches of modern governments are closely related and connected, they have to coordinate and cooperate rather than become strictly separate and independent in order to fulfill huge and complex responsibilities. Number 2. One organ of the government has to perform the functions of another organ and exercise the powers of another organ. Lasky finds out that overlapping of functions of Lasky finds overlapping of functions of the three organs of government. For example, in the modern complex system of governance, it is not possible for any organ to operate as self-sufficient unit. Enactment of law is the function of legislature, but when the legislature is not in session, the executive makes emergency laws for the time being. Moreover, the judges, in the absence of necessary law, settle disputes according to their personal judgments and moral sense. Their verdicts create new laws as precedent. Again, adjudication is the function of judiciary. So also high-ranking officials are tried in legislation. So also the high-ranking officials are tried in the legislature. The president can commute sentence and grant pardons in the USA and India. Number 3. One organ of the government determines the other two. In parliamentary system, the executive remains accountable to the legislature. So with the aid of organized party system, the executive exercises control over the legislature. Again, the judiciary can annul the law made by the legislature and order passed by the executive as unconstitutional. Again, the judges of the higher courts are nominated by the executive. The President of USA can veto the legislation passed by the Congress, and Congress can override the veto with 2/3 majority in both houses. The American Supreme Court can challenge the legality and fairness, and moreover can outright the Congress-made laws. Number 4. Now the same person is connected with more than one organ. The monarch of England and the President of India are the executive heads of the country, and at the same time the integral part of the parliament. The members of the major party in the parliament becomes ministers. Lord Chancellors, the head of the House of Lords, that is the upper chamber of the British Parliament, is a judge of the Supreme Court. So, Justice Frankfurter said, enforcement of rigid conception of separation of powers would make modern government impossible. So, the theory of separation of powers are based on 4 basic principles, and here in this point we have discussed that none of them are practically possible. Point number 2. Practical implementation is undesirable. From the point of utility, implementation of the theory of separation of powers is not desirable even if it is possible. The efficiency of the government is dependable on the cooperation among the different organs. Total separation of organs will create conflicts rather than cooperation. As a result, the government will become ineffective. Besides, separation of powers will result in competition and contradiction among the organs of the government, which lead to the administrative deadlock. If the theory is applied, every organ will concentrate on expending its power instead of performing its duty. Predominance of the narrow sectarian interest will jeopardize the interest of the whole. The principle of separation of powers, in finest words, throw governments into alternate phases of coma and convulsion. Number 3. Adverse effect of practical implementation. If complete separation of power is implemented, it may affect adversely. For example, in some states of the USA, to ensure the independence of judiciary from the influence of the legislature and the executive, the judges are directly elected by the people. So, the judges are selected on the basis of their popularity rather than their skills and competence. To win such elections, such judges are always seem to busy to please the popular political party. So, their justice become a fierce. Number 4. Difference of opinion regarding classification of the functions of government. The theory of separation of power is based on the principle that the government has 3 types of functions and has 3 organs to perform those functions. A number of political scientists has criticized this theory by saying that it is wrong to hold that the functions of the government are of 3 types, but they differ on exact number of the functions of the government. According to the philosophers like Goodnow and Jenks, the government has 2 organs, the legislative and the executive, because the government performs 2 types of functions, that is the legislation and governance. In their opinion, judiciary is a part of the executive, Again, political scientists like Willoughby thinks that the functions of the government are divided into 5 categories. So the government comes to possess 5 organs. Legislature, judiciary, officials of the executive, general staff of the executive and the electorate. Number 5. All organs are not of equal power. According to the theory, every organ is supposed to be equally powerful, but the presumption is not correct. The executive rules according to the law and the judiciary interprets law. So, if the legislature does not make law, the executive and judiciary will have nothing to do. Hence, in parliamentary democracy, legislature is stronger than the judiciary and the executive. However, in the opinion of Barker, the supremacy of the executive is noticeable in modern times. The executive uses its authority and power to make laws indirectly. It may be debatable that which department has supremacy. However, it is evident that the 3 organs of the government does not hold equal power. Number 6. Arguments of the advocates of organic theory. The advocates of organic theory like Bunsley opine that different organs of the government are organically related to one another. As a living being cannot exist without the cooperation of all the parts of the body, similarly, the government will come to a standstill if there is no cooperation among the 3 organs of the government. Number 7. Separation of powers is not essential for the enjoyment of liberty. The fundamental object behind Montesquieu's doctrine was liberty and freedom of individual. But according to the jurists like Sabine and Gilchrist, that cannot be achieved by mechanical division of functions of power. Mechanical divisions of functions and power. In England, the theory of separation is power. In England, the theory of separation of powers is not accepted, yet it is known for the protection of individual liberty. For freedom and liberty, it is necessary that there should be rule of law and impartial as well as independent judiciary and eternal vigilance on the part of the subject. Number 8. Marxist view. Marxists believe that the three organs of the government remain under the control of the same class, that is, the class which is in power. So, according to them, separation of power is nothing but a myth. In socialist system like China, the theory of separation of powers is not acceptable. Number 9. Not suitable for emergency. To ensure speedy and simple transactions, the branches of government must coordinate with each other. However, if this principle is applied, there would be a hindrance in cooperation and speedy transactions. So, this system is not suitable in case of urgency. Number 10. Disputes regarding jurisdiction. Application of this theory may create complications in governance. There may be problems of jurisdictions among different organs on marginal and residual issues. Number 11. Increase inefficiency. This theory may give rise to a sense of irresponsibility among different organs. One organ make it away by attributing its inefficiency to the other. Lasky also believed that if the legislature, the executive and the judiciary are completely separated, then each organ will try to avoid responsibility and seek to devolve it on others. Separation of powers will give rise to conflicts and confusions. Besides, in John Stuart Mill's view, a difficult deadlock will result in organs of the government remain completely independent. A difficult deadlock will result if the organs of the government remain completely independent and if they enjoy strictly demarcated spheres. For each organ, in that case, will try to preserve only its own interest and only perform the duties assigned to it. This process will bring down the government's efficiency. Conclusion. In conclusion, we may say that in modern complex administrative system, complete separation of powers and functions is neither feasible nor desirable. However, there is no denying the fact that accumulation of all powers of the government in the same hand will invite despotic rule. In the interest of individual liberty, partial application of this theory is necessary. Partial application means number 1, independence of judiciary, and number 2, separation of the modes of function. Independence of judiciary is vital to individual freedom, and separation of the modes of function means a democratic welfare system where one organ will do the work of other to a limited extent and by following the due procedure of the latter. This is the modern proposition of this theory, which is being followed by almost every nation, including India. If you like this answer, please share it and subscribe our channel, and please like this video. Thank you.